Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss about the CDRs, call detail records, call detail registers, or mobile conversations, whether they are admissible in evidence or not. So this is the important point. So already as IT Act students, you all know that section 65A, 65B, they have been amended of Indian Evidence Act. They have been amended only for the purpose of enabling the electronic evidence into the ordinary old evidence. Simply I tell you, suppose if there is a dispute regarding the age of a girl, so the court wants a certificate from the headmistress of a particular school. Yes, if the court directs that woman, yes, she has to produce the document. For that, what she has to do, she has to make a copy of the extract of the 10th class or date of birth certificate. Then she has to sign, then she has to affix a signature, then she has to send it through some of her colleagues or juniors. But in that place, if the document is electronically generated and a copy is sent to the mobile or computer of the magistrate, it would suffice. This is the importance of the Information Technology Act. And friends, you may be knowing, so technology is developing like anything. So definitely we have to catch the technology, even the judiciary also. Therefore, please remember, so the evidence of or the CDRs of mobile, definitely they are admissible. Of course, please remember, they are not admissible unless it is accompanied by a certificate under section 65B of the Indian Evidence Act, that they have been photographed or they have been taken from this particular mobile. That certificate should be there. Otherwise, if it is a morphed copy, then how can court will accept? So that the problem is there. So please remember, definitely electronic evidence is admissible under section 65A of the Evidence Act. At the same time, you have to give a certificate that this instrument is used for recording the same. That is what is called 65B. But here, the lower courts, even at the level of High Court, they have forgotten, the defense has forgotten to put this question. Whether the certificate is there under 65B or not, they have forgotten. Ultimately, the matter was discussed in the Supreme Court. Supreme Court said, see, if at all you want to raise any objection of such points, you have to raise in the earlier stage, not in the appellate stage. We are not going to admit the same. That's why main reason is that they have not raised an objection in the first instance. But anyway, so CDRs are definitely admissible. Therefore, yesterday also I have seen a man from Canada, woman from India, they have discussed with each other on the WhatsApp message before the court and the divorce has been granted. That is the advantage of the electronic evidence. Or video conferencing, number of occasions. Even sometimes the courts themselves, they are stating that don't produce the accuser before physically the court. It is video conference is sufficient and remand is also being given. So these are the stage. So now our case is, please remember, whether electronic evidence is admissible or not. 100% admissible, there is no doubt. Here it is a typical case. You have to read the cases Sonu alias Amar versus State of Haryana 2017. You can see it All India Reporter AIR volume number 4 page number 3441. Right. Here what happened is, please remember, it's a case of ghastly kidnapping and a murder. On 25/12/2005, Ramesh Jain, actually his son Pankaj Jain, both of them went to the rice mill. Pankaj Jain came early around 7 p.m. Normally, the old man Ramesh Jain used to come at 9:30 or 9, but he did not come. Then the son tried to contact him. The cell phone was switched off. They got a doubt. They thought that old man, he might have gone somewhere. He would have come on the next day. And the next day, by morning, they got apprehension and fear. And they searched here and there. They inquired the relatives. Ultimately, the person was not found. Ultimately, they reported the matter. But ultimately, on 9/1/2006, that is almost after 20 days or so, they received a call from Mr. Bunty. He is an accused in this case. So for a ransom of rupees 1 crore. Arey Baba, your father has been kidnapped by us. He is in our custody. So if you pay 1 crore, then only we will release him. Otherwise, no. Then he informed the police. Of course, the police also tried, but they were not successful. Ultimately, the dead body of the deceased was traced at some place. The motorcycle was also traced at some place. Kidnapping and murder case has been registered against many accused. Out of them, this man is A5. Sonu alias Amar is A5. The allegation against him is that the accused persons left the mobile phone as well as the documents in the shop of A5 Mr. Sonu alias Amar. So let us come to this point. Whether the call data between Amar and the accused persons is reliable or not. Number 2, whether the document seized from his position are reliable or not. Definitely document they have got a measure. As regards the mobile calls, then they made an analysis, they sent to the laboratory, ultimately they have filed the case also. Now the problem is, yes, the voice is up, the call records, voice, all these things they have verified. Now the point is, yes, it is accepted by the trial court. They did not raise any objection. Accepted by the High Court, they did not raise any objection. When the matter has come to the Supreme Court, then only they raised objection. Now Supreme Court stated that the permissibility of the objection. So please remember, the objections can be raised at the time of trial. Even at least before the High Court, they have raised some leverage would have been taken. But here, after all the things are over, you are coming to the Supreme Court and saying that it was not given a certificate of the 65D, now 65B of the Indian Evidence Act. We are not going to consider the same. So, basing on the technical ground, the case has gone. So, still the conviction they have to suffer. We can't help. So, what you have to learn from this case is, please remember, as a defense advocates, if any mobile evidence, if any electronic evidence is produced before the court, they have to enclose a certificate under section 65B of the Indian Evidence Act. That's more important. Plus, the comment by the Supreme Court is, Indian Evidence Act is no more res integra, RES, res integra. What is res integra? A case or question that has not been examined or passed upon. So it is not res. Already we have decided, we have told in number of cases that certificate has been enclosed, has to be enclosed, but it is your fault not to raise objection in the initial stage. Now we can't do anything. Case gone. So please read the case and enrich your legal knowledge. Thank you.